The ongoing litigation before the U.S. Supreme Court concerning a Rastafarian inmate whose religiously mandated dreadlocks were forcibly cut by prison officials centers on a fundamental question. Does the Religious Land Use and Institutionalized Persons Act, RLUIPA, authorize monetary damages for past violations, or is relief limited strictly to injunctive orders that force a change in policy? Current reports and analysis of oral arguments suggest the court is strongly leaning toward the latter, a decision that would significantly narrow the financial accountability of state correctional systems for infringing upon religious liberty. Summary of the issue. The heart of the case involves a Rastafarian individual whose faith requires the uncut wearing of dreadlocks. Upon entering a state correctional facility, the inmate's hair was removed by staff, a clear burden on his religious exercise. The inmate sued under RLUIPA, a powerful federal law passed by Congress to protect religious freedom from governmental overreach, particularly targeting prisons and zoning boards. RLUIPA stipulates that a government must not impose a substantial burden on the religious exercise of a person residing in or confined to an institution unless it can demonstrate that the burden is the least restrictive means of furthering a compelling governmental interest. While the underlying religious violation appears clear, the legal battle has shifted entirely to the nature of the remedy available under the statute. The question is not if the right was violated, but how the inmate can be compensated for the emotional distress and harm caused by the violation. Analysis and reasons for court hesitation. The Supreme Court's hesitancy stems from two key factors: statutory interpretation and deference to state sovereignty. First, RLUIPA's text allows a person to sue for appropriate relief, but does not explicitly use the term damages when creating the private right of action. Supreme Court precedent, particularly under the spending clause, dictates that if Congress intends to subject states to monetary liability, especially liability that can bankrupt or severely strain state agencies, it must do so with unmistakably clear language. Because RLUIPA lacks a clear, unambiguous statement authorizing damages against states or state officials acting in their official capacity, several justices signaled during arguments that they would be reluctant to imply such a drastic financial remedy. Second, there is a deep-seated judicial concern regarding the administrative burden and potential litigation explosion within the prison system. Granting broad access to financial damages could incentivize a massive increase in lawsuits against correctional departments, diverting taxpayer funds and staff time away from core security and rehabilitation functions. The justices are carefully weighing the constitutional imperative of religious freedom against the practical realities of managing institutional order and state budgets. The ability to win injunctive relief, which forces the state to change the problematic policy for all future inmates, already provides a substantial systemic remedy. Consequences of denying damages. A Supreme Court ruling that limits RLUIPA relief solely to injunctive relief would carry significant consequences. Weakened accountability for past harms. Without the threat of financial damages, prisons have less incentive to proactively respect RLUIPA. Policy change is a future-focused remedy. It does nothing to compensate the individual for past pain, suffering, or distress. Policy violations could continue unchecked until a successful lawsuit forces a costly, lengthy policy adjustment. Increased reliance on Section 1983. Claimants would be forced to rely on 42 U.S.C. Secretary 1983, the primary federal civil rights statute, to seek damages. This is a much higher legal hurdle, requiring the inmate to prove a constitutional violation, often of the First Amendment, directly against individual officers, rather than utilizing the broader, more protective standards of RLUIPA. Financial immunity for institutions. State correctional departments would effectively be shielded from financial liability for systemic religious freedom violations, transferring the cost of such infringement from the state to the injured inmate. Prediction and potential solutions. Prediction. Based on the current legal landscape and the tone of the oral arguments, the Supreme Court is highly likely to rule that RLUIPA does not clearly and unambiguously authorize monetary damages against state governments or their agencies. Injunctive relief. The court ordering the prison to permit dreadlocks and change its hair policy will remain available, but the financial remedy for the past violation will likely be denied under this specific statute. Solutions and alternatives, legislative clarification. The most effective solution is for Congress to amend RLUIPA to include an explicit, clear statement that monetary damages are available against state institutions for violations of the Act. This would satisfy the Supreme Court's unmistakably clear requirement. Individual liability under Section 1983. The inmate can still pursue damages against the individual prison guards responsible for the act by filing a claim under Section 1983, arguing that their actions violated his First Amendment free exercise rights. While challenging due to qualified immunity defenses, this avenue remains open. Enhanced internal training. Correctional facilities must treat RLUIPA as a mandate, not a suggestion. Proactive solutions involve implementing comprehensive, ongoing cultural and religious sensitivity training for all staff, ensuring policies are the least restrictive means possible, and establishing clear internal reporting mechanisms to prevent such incidents before they escalate to litigation. A well-trained institution is the best defense against both damages and injunctive orders.